Good evening, everyone. Welcome to the International Privacy Day celebration of FDPPI. FDPPI organized two activities around this day, celebrating International Privacy Day, a data privacy pledge, which we tried to involve all privacy professionals through social media, and this legal debate today on right to be forgotten. So today's discussion, there is a panel discussion followed by a moot court today. The theme of this event was inspired by a truly remarkable judgment from the Kerala High Court in December. I'll not elaborate on that. Navisa will give more insights about this case. So we have the theme of right to be forgotten, and we have a panel discussion and a moot court around that. Let me briefly introduce the panelists today, who are eminent professionals and FDPPI members. Navisa doesn't need an introduction. He's a pioneer in cyber law and data protection in India, an ex-banker with wide experience in marketing, merchant banking, and information security. He's author of many books and a thought leader with innovative concepts such as the Personal Data Protection Standard of India, Data Valuation Standard of India, Online Data Trust Score Self-Evaluation Tool for SME and MSME, and also developed sectoral codes of practice. He's a qualified independent director certified by IICA. He is now aspiring and working towards neuro rights legislation, which is a novel concept in India. We have MG Kodandram sir, who's a retired IRS. He's an advocate and consultant. He's practicing in indirect tax litigations. He has handled 2,000 sessions to various trade bodies, government authorities, and tax practitioners on topics relating to customs, GST, IPR law, cyber law, and forensics, vigilance, RTA, and related matters. He is an author and a guest faculty in over 50 institutes and academies. Advocate Dr. Mahendra Limaye, techno-legal expert in cybersecurity and cyber legal education. He's a diploma holder in mechanical engineering with masters in law and PG diploma in cyber law and information technology. He's also awarded a PhD in cyber laws from RTM Nagpur University. He is a guest faculty for cyber laws and cybersecurity for various educational as well as government training organizations. His views on cyber laws and cybersecurity are regularly published in various newspapers. He practices in cyber litigation, data protection as specialized domain. Ms. Ruchika Kumar is an advocate specializing in intellectual property for more than 15 years, currently associated with Krishna and Sarashri Associates LLP. Her practice areas include trademarks, copyrights, and designs. Ruchika holds a PG diploma in cyber laws and cyber forensics from National Law School of India University, Bangalore, LLB from Delhi University, and a PG diploma in global sales and marketing management. She is also a certified personal data protection compliance auditor from FDPPI, as well as a BSCI certified privacy professional. Our next panelist is Abhay Varik, an engineer by profession into technology, data storage, replication, and backups for almost 20 plus years with HP and Dell, and equally associated with information security as a CISA certified auditor. This includes 4 years of legal profession as a data protection attorney, and now an associate with Dr. Limaye for handling cyber law matters at Mumbai. Ms. Tripti Kumar is General Counsel of CMSIT, where she heads the legal compliance and privacy areas. Tripti is a university rank holder in BA LLB honors and holds a master's degree in international business laws. She brings with her more than a decade of experience working as a legal counsel in law firms and in-house. Her professional journey includes working as litigation counsel and corporate lawyer for a diverse portfolio of clients. We also have two law students in the panel. Neha and Vaishnavi are students of KLE Society's Law College. A very warm welcome to all of you. Over to Navisa.
Good afternoon, friends. And first of all, greetings to all of you on this International Privacy Day. This year, it appears to be a very momentous year for several reasons. Of course, in India, we are expecting our new Data Protection Act also to come during this 2023. So this will be last International Privacy Day we will have before our own act will take into come into action. Now, on behalf of FDPPI and all its members, I wish all of you whatever you think is good for privacy in India, let it happen. Fine. Now, this year we also introduced a new trend in the market where individuals take a privacy pledge. We started that 15 days back, and we are very happy to notice that other organizations, including DSCI, have also started taking this similar privacy pledge from people. So the professionals now have a sort of a commitment to the society on their privacy stance. Of course, what we have tried to do is to have a privacy pledge where a professional will assure the community that they will be protecting the privacy of the community. And DSCI also has got something to say that they will protect the privacy in the way it will protect the individual, that is the person who is pledging. Since we are an organization which is more, say, oriented towards the public and we are the professionals, we have a responsibility not only to protect our personal interests in terms of privacy, but also the protect the privacy interest of the community. So our pledge is more, you can say, outward looking. A lot of people have already taken that pledge. We have also issued the certificates. That pledge, this thing will be open for a few more days, perhaps, and then you can try to take the pledge if you are interested. The idea is to ensure that we are not only aware of what we need to do, we are internalizing the commitment to the society. That being one of the achievements of this Privacy Day, this particular event basically is to discuss all about this concept called right to forget. As you are aware, right to forget was a concept which was introduced by GDPR in the latest 2018 version. In the old directive, it was not there, but somehow it has been introduced as a right of the data subject as per the GDPR. And probably it came because the EU court also thought it was necessary in one of the cases involving Google. And because of that, the EU has added this as an important right. Now, we in India are still not perhaps fully understood the need for right to be forgotten. Okay, that is the right terminology if you want to use it. And as we know that the earlier version called FDPPI 2019 had one section on right to erase, another section on right to be forgotten. So there was a distinction between the two. We had understood it in some particular manner. Now FDPPI 2022 has retained right to erase, but is silent on right to forget. So that is something which legal people will need to understand what is the legislative intent of the Indian legislators. In the meantime, we had this very momentous judgment which came from the Kerala High Court, which was very, very educative in a sense that it gave some information about the way right to forget evolved over a period of time, and really it has added to the entire knowledge base of the Indians on this concept called right to forget. And therefore, today's discussion will revolve around what this Kerala High Court has given as a verdict. I suppose you are able to see this screen. Just confirm.
Yes, sir.
Yeah, okay. Now, this 20s, I will just give a brief about this particular case, because our objective in today's activity is to actually try to impart some information and knowledge. We have chosen the format called moot court. Therefore, there will be experienced advocates trying to put across their view on one part or the other. That will start after a while. But before that, we would like to use some time to actually explain certain concepts so that the educative part of today's this thing is not lost before the legal experts start talking about the issue in a manner in which it is normally discussed in the court. Those of you who have got legal experience will be able to understand the moot court concept much better because you are aware of how the courts function. Whereas a lot of technical people may not have a clear understanding of what a moot court means, though we must thank Supreme Court nowadays because they are live streaming the court proceedings. So to some extent, people do get an idea of how the court functions. But still, what may happen in a moot court competition is that the more knowledgeable legal pundits will be putting across their views. So some of us may actually lose the context. That is why we thought we will have this particular discussion in two parts. Initial part will be through a panel discussion. We will try to introduce certain basic concepts which are essential to be understood before we actually start the moot court proceedings. So in that panel, we are going to have the experts who have already been introduced to you. I will try to moderate that panel so that some learning points are brought to the attention of the audience. Before we start that, I thought the audience should also have some idea about this Kerala High Court judgment. So I'm going to take only a few slides to explain what this Kerala High Court judgment is. This was delivered on 22nd December. It was a two-member bench, Justice Muhammad Mustaq and Justice Shobha Annama Ipan. They were assisted by an advocate, B.G. Harindranath, more or less like an amicus curiae. And I personally feel that there must have been a lot of contribution from this gentleman for the way this whole judgment has been presented, as if it is a kind of a textbook on right to forget. Those of you who are college students must look at this judgment again and again to understand several principles of privacy and then this right to forget. This case actually came to this bench on a reference from a single bench of Justice Mr. Nagendran. In one of the petitions he had received, there was an application about a contracting marriage under a Special Marriages Act. Now, party to that proceedings, whether their names have to be masked in the judgment or not, was a point which the petitioner had raised. And the court had several cases of that nature, some of them are criminal cases, where after the judgment or in the respective case, the petitioners had some reservations about their judgments appearing in Google or India Qanun, where the title of the particular judgment included the name of the petitioner or even the respondent, both will be there. And many of these people brought a request to the court that it is not supporting this concept of right to forget. By that time, actually, right to forget had been discussed by Delhi High Court, Bombay High Court, maybe Madras High Court. So 3-4 high courts had earlier discussed right to forget in this kind of a situation. So I think these people had a right to approach the court. Now, apart from this one case for which reference was initiated, the court actually clubbed several other cases. It is interesting to note that some of these cases were actually criminal cases. For example, one was a case under 354D, talking of a woman. In this particular case, complainant had withdrawn the complaint and the withdrawal was allowed, but the judgment was published in India Canon and it was indexed by Google. In another instance, there was an accused dentist. He was accused in a criminal case, but had been acquitted. Bail had been granted. The bail order was published by India Canon and indexed by Google. In another case, the mother of a girl had filed a habeas corpus petition regarding her missing daughter. So both of them, mother and daughter, were the petitioners in this particular case. And this petition also had been closed by some mutual settlement, but it was published by India Canon and Google. And the petitioners contended that the publication causes prejudice to the daughter because her identity has been exposed. In another case, there was a lady who wanted to solemnize her marriage with a US citizen. Court directed the marriage officer to do the needful. But however, marriage did not go through because of the differences between the parties, not for any other reason. But the judgment allowing or directing the marriage officer to solemnize the marriage stayed. And that was available in India Canon, Google, and others. And now that they are no longer married, probably the lady felt a mental trauma about that and also felt it was not in the interest of decency that her identity should be finding a place there. In one more case, there was an anticipatory bail granted to a person who was a homeopathic doctor. Again, this was a criminal case. The criminal complaint had been quashed. In other words, this person had been acquitted. So there again, the same issue, the names are available in the judgments. In another criminal petition, again, petition was squashed because of the settlement of the parties, but there were other accused apart from the person who went, main person who went for settlement. There were other accused, and one of those persons felt that these people have already closed the case, but my name is still appearing in the India Canon. In one more case, the petitioners' parents were arrayed as parties of opposite sides. That was again somewhat unsettling for this petitioner. In one more case, there was Section 67B of Information Technology Act, protection of children from sexual offences was involved. In another case, a petitioner's residential address, name, everything was published because it was a child custody case. So in all these cases, there was an issue of a request for right to be forgotten, to be exercised by removing the names in the judgments. And the main contention was that these judgments are available in Google and India Canon. So there is an issue. The court combined all these things and came to mainly the four conclusive findings. One was that it declared that a claim for the protection of personal information based on the right to privacy cannot coexist in an open court justice system. So the court said that India follows an open court justice system and that has got certain requirements. We will discuss what is an open court justice system in the panel. Compared to that, there are cases which normally are allowed to be held in camera kind of a thing, where perhaps a decision can be different. So the court said we hold the right to be forgotten cannot be claimed in certain proceedings or in a proceedings of recent origin. The court also made a distinction between proceedings of a recent origin and proceedings of some time back. see, we all know that humans actually have a tendency to forget over a period of time. Unfortunately, technology does not forget. So somehow the court felt that time is also an essential factor to be considered. In fact, it said that this is the actual position as of now in law. It is for the legislature to fix grounds for invocation of this right to be forgotten if it thinks necessary. But the court said that having regard to the facts and circumstances of a particular case and the duration involved related to the crime or any other litigation, it may permit a party to invoke the above rights or de-index, that is for the Google kind of search engines, and to remove the personal information from such engines. The court in appropriate cases is also entitled to invoke principles related to right to erasure to allow party to erase and delete the personal data that is available online. Again, the court made the distinction here that court can in certain cases allow this right to forget, and in certain cases it may restrict it only to right to erasure. The third point which the court declared as a finding is, we declare and hold that the in family and matrimonial cases arising from the family court jurisdiction and in other cases where law does not recognize the open court system, the registry of the court shall not publish personal information of the parties or shall not allow any form of publication containing the identity of the parties on the website or any other information system maintained by the court. It also felt that the registry of the High Court is bound to publish a privacy notice. So these are the four essential findings of this particular judgment. But to arrive at this, they had a lot of discussions on the entire requirements under these criminal cases and matrimonial cases. So this is the background. And now we will try to go to the panel of experts. I wish all the panelists are there now. Now we will try to understand some of the issues which the court has addressed, because we may not be experts kind of a thing. There will be both technical issues. There will also be legal issues. Okay. I suppose Ruchika and Trupti also will join. Okay. My first question to the panel. Of course, today in our proceedings, after this panel, until the panel discussion is done, I am a panel moderator. I am representing FDPPI. After the panel is over and when the moot court starts, me and Mr. Kodan Raman, we will take on a role to sit and hear what the arguments are. Okay, because somebody has to sit in that chair, so both of us are sitting in that chair because we are the oldest persons in the lot. Okay, so right now I'm only a moderator of a panel a discussion. Okay, so my first question, which of course one of the legal persons can take, is now whenever we talk of privacy in India, the first judgment which comes to our mind is the Puttaswamy judgment, because that becomes the referral ground for anything. So now what we have to question ourselves is that what is this right to forget and how is it related to right to privacy? Is it a fundamental right under Article 21 of our Constitution? If so, how? Now, we say Article 21 is subject to reasonable exceptions. If so, for right to forget, what are the reasonable exceptions? So this is the point which I would like, say, who will take this? Ruchika, you will take this? Yeah? You have to unmute yourself and then take it. Does right to privacy include right to forget? Can you say that this is what Puttaswamy judgment has said? Because in India, we don't have any other judgment. Okay, so yeah, please.
So Dr. Limai would be more competent to answer that question.
Dr. Lemay?
Okay. So the question is very tricky, that whether right to be forgotten is intrinsic part of right to privacy. So normally right to privacy is assumed to be to keep oneself in his own isle. He should be free to do whatever he wants in his own isle. That is what is right to privacy as extended in Puttaswamy judgment. So when I am in my isle, I should not be disturbed by some external elements due to whatever information of me is available in public domain. That could be the extended logic of this particular right to be forgotten, because whatever I have done, if somebody has pardoned me, so just for imagination, if I had done some mistake and my teachers have pardoned me, so whether that mistake should be repeated continuously, and when this particular act is done in some privacy, whether I have some rights to not make this particular act so private, which is so public, which is made in public domain with the upcoming or emergence of social media. So though right to be forgotten, when each and everything is available in social media or through online channels or online websites, is somewhat difficult, but the understanding of right to privacy having inbuilt the right of forgotten is what our lawmakers had at that time in mind. But when we come to PDPB 22, we see some modifications or some migration or some deviation from the provisions of original PDPB, where right to erasure as well as right to forgotten, both the rights were explicitly mentioned. And in this new version, they have only mentioned about right to be erasure. So there may be some dilution in the understanding of lawmakers, that right to erasure and right to be forgotten are somewhat having different shades to its existence, and that's why they had only specifically mentioned about right to erasure. Another point of contention is that when we talk about right to be forgotten, who will forget? Because when the incident is seen by entire world, how you can make only some limited intermediaries to forget that particular thing? What about the other persons or other medias who have captured that particular incident secretly, and they have recordings or some evidences of that particular activity? Like court has said that right to be forgotten is available, or right for erasure must be available in open court system. When our judiciary itself says open court system is much desired and it should be popularized as much as possible, then whether this particular right to be forgotten should be available in open court system is another debatable question, when we talk about right of privacy and right to be forgotten inbuilt in that particular right to privacy. So according to me, it is very confusing situation right now, because even our lawmakers have not come clearly on what is right of erasure, what is right of forgotten, and what are the inbuilt ingredients of right to privacy. So we have our own ideas and our own wisdoms to follow, and this is what my wisdom says, that right to be forgotten is one part, but practically it would be too difficult to implement that particular right to be forgotten.
Thank
That
you.
is what my take is, sir.
Okay, I would like to go to Trupti now. Now, so okay, Mr. Lemay spoke about the legislation, but I want to know what was Puttaswamy judgment's view on the right to be forgotten, whether it should be part of the privacy or not. What is your view on that?
So, firstly, good evening, everybody, and wishing you all a good day today. So, now we saw, coming from the Puttaswamy angle, right to be forgotten was considered under privacy, where privacy was considered inherent to human dignity under Article 21. Now, if you look at dignity, dignity is very inherent. But if you look at something, the way right to privacy is being interpreted, it is more reputational. Now, reputation can come and go. It can be good, it can be bad. It can be positive, it can be negative. Today, we all are saying right to forget more in a negative stance. But what if it is a good, somewhere we are very popular or some article praises us? Who will raise a right to be forgotten then? So ideally, it is more situational that a person has a right to safeguard his reputation, the way it is being interpreted, but not protecting dignity. Whereas in Puttaswamy, the Article 21 umbrella that was discussed, and I think there's an obiter also in that, was that it is under right to dignity. Privacy is a matter of dignity, not a matter of reputation. It is being interpreted as reputation in the online world, because the way we project ourselves, the information that is either being circulated about us or we ourselves are voluntarily putting it out there, it is to impact our reputation the way we are perceived. Whether it's an organization, how is it perceived outside? Whether it is as a person, how am I perceived? Today, even in the media and the marketing world, we have people who are managing your entire public persona. There are digital marketing, what content goes out, everything is regulated. So I think adding to what Dr. Limai just mentioned, it is inherent from a privacy angle to protect dignity of a human being or dignity of any living being for that matter. But to make it synonymous with right to reputation, so right to reputation was never part of fundamental rights. It was only right to inherent dignity. And I think that is the distinction that Puttaswamy did bring in. And they linked it to Article 21 for that reason. That is my thought on it.
Okay, so you are deriving this right to forget from the right to dignity kind of.
Yes,
thing.
that is the Puttaswamy judgment. It's under Article 21.
Okay, okay. Ruchika, you can also add your views on this. Did Puttaswamy judgment specifically talk about a definition of privacy and or allowed it to be just derived from this right to dignity? Now, if the court says right to dignity, then I have to again run around and say, what is right to dignity? What is it included? What is not included? Now, where did the court actually speak about this right to be forgotten in this judgment? Was there any specific mention of it in either the final judgment, which legal people may call it as a ratio of the particular judgment, or was it a part of the arbiter dicta, what Trupti was telling, when they discussed larger issues? After all, it was a 547-page judgment in which one page was the last discussion. So other 500 and odd pages had various discussions. Okay, so what is your view of how do we read Puttaswamy judgment into the right to be forgotten? Because if we don't invoke Puttaswamy judgment, we are only dependent on what the government brings out as a law. And if in the government DPPPI 2022, if there is no mention of right to forget, where from will we import that concept of right to be forgotten? Will we invoke it from GDPR and put it into Indian courts? Or will, I don't know, the other lawyers are going to come in the moot court to argue whether we will try to have GDPR jurisdiction in order to justify right to forget in India, or is there anything in Puttaswamy judgment itself? That is what you can also add, because it's a very important point on which the entire discussion will lie. Yeah, Trupti. As Ruchika. Yeah.
So personally, I feel that the times of us adopting law from European countries has gone by. So it has, now we are in a scenario, and I think we have enough jurisprudence and I would say intelligent people who can actually analyze what is required for a unique country like India. So I don't think that a concept can be just picked up from a European jurisdiction and implemented in India. That is my personal view. I'm very nationalist that way as well. So I will never advocate something like that to be done. Puttaswamy judgment is a very good judgment, and it did invoke a lot of, I would say, a lot of thought processes generated because of that judgment, and a lot of discussion has been generated on various aspects. I agree with Tripti on that what it talks about is right to privacy is a right which is a dignified living. So whether a right to forget can be claimed as a right to dignified living, that I feel is going to be a case-to-case scenario. It cannot be a blanket right. Like all fundamental rights are not absolute rights. It is very clearly stated in the Constitution, you have fundamental rights, but they are subject to reasonable restrictions. So it cannot be just as a blanket. You cannot say right to be forgotten is there for everybody in every scenario. I feel it has to be a case-to-case basis, wherein it is required for a dignified life of the individual. If it is not required for the dignified life, or it is affecting the public sphere, if that right to be forgotten is granted to the individual, the counter effects is going to affect a larger population, then again, there is a qualification that has to be placed on it. It cannot be an absolute right.
Okay. Now we'll go to one small technical doubt which I have. See, people are talking about this removal of data from the hands of India Kanun or say the Google. Now, technically, is it possible to redact or remove information which has already been put once on the internet? Abhay, can you just provide your views on that?
Yes, sir. So if you look, the data that once goes on internet, okay, is basically very difficult to track on. Okay, where if people like or organizations like Google who have taken necessary precautions where the data has been there, cannot be copied, that's one other thing. But we still don't have that technology in place where data which goes on internet cannot be further copied on. We have crawlers available on the websites which captures the data. So even if we have people, even the code restricting Google or India Kanun or anyone to restrict the data or to dealing the data or to delist the data, okay, data is still available in the internet which is captured by other entities, and that is where it is very difficult to track. We don't have technology where data is at the initial stage itself. When it has been created, it can be tagged. The tagging mechanism is basically useful to understand or for data inventory part of it. If that mechanism is not in place, it is very difficult because the data then gets replicated in its own form, in its own way, in its own format. And then deleting, though there is a strict restriction from the code for Google or for India Kanun to delete the data, it's not that simple because it's been already copied by other entities. Moreover, when a data goes into a cloud or any of the platforms, say for example, my name itself, when it goes to Abhay Warik in any of the cloud platform, it is just not the data of Abhay Warik it goes. There is an additional data that is being created, a data called as metadata, a data which the platform itself generates, a data which the technology called as a profiling which is generated. So with the single name of the name of Abhay Warik, it's not only a single data it goes, but the single data going within the system, there are multiple additional data that has been created. So when a code asks someone to delete or forget a data, it is not a particular data. There are other pieces of data which has been created because the data which has gone online of the system, additional data has been created, and it's very, very difficult to catch up on this part of it.
I have got one supplementary question on this. Now we have got India Kanun, we have got Google. Now Google does use a technology of crawling. Okay, what do we mean by crawling? Its robots actually go through the content, and basically I think they are having a keyword kind of an identification. Based on the availability of the keyword, they will index the content. Okay, so that is indexing. Whereas India Kanun may actually go to a closer to the source, like the judgments repository or database, and from there pick up the entire judgment. And of course, it also categorizes, and that way it does indexing of its own. But indexing of India Kanun is different from indexing of Google. Is it correct to describe like that from technological point of view?
Yes, sir. So everyone has his own indexing mechanism if you look into that part of it also. Okay, so it's not that indexing what Google does has to be exactly the same or is worldwide followed. Okay, the technology of indexing depends on the applications that we have in the systems. Okay, so it's not necessary what India Kanun is, the indexing technology has been used, it has been followed by Google, or it has been used worldwide. Okay, so there is no standard format as such which is there.
Yeah, Gautam, you want to say something?
I wanted to ask one more technological
Yeah.
related question to Abhayji. Abhayji, in the Delhi High Court, in the Ramdev's publication case, said speaks of global blocking. Means all over the world, the content should be blocked. That is the order given by the Honorable Justice there. Is it possible technologically to prevent it, or it becomes only a kind of a paper threat for them to be followed or not otherwise? Because I don't think the way you are telling, blocking itself is difficult, and globally all those contents to be blocked may be nearly impossible. And by this kind of technological inefficiency, whether we are allowing dilution of certain rights of the human beings?
Sir, if you look into this part of it, with the current technology, we have now many tools, okay, where the data, when it gets itself ingested, is been tagged so that, it can be, it can be tracked on the cloud itself. But with the legacy types of data that we have, it's very next to impossible. And where the data is on cloud like Google, okay, it's not that it is residing on a particular region. And moreover, it's a way where, the system has to develop itself with not only people, process, but also technology has to be in sync with it. People need to understand that, yes, I need to follow a certain process. I need to take all these things into consideration before the data I absorb in my system itself. People don't take that into consideration and just ingest the data and then use the data in that way they want. And so blocking, as currently, if with the legacy system that we have, no, but if systems been implemented with the new technologies that there in the system currently which are coming up, you can very well track the systems and delete it, okay, and limit the usage of it.
Okay, now we are in the era of OpenGPT, okay, artificial intelligence. Now, same artificial intelligence can perhaps be applied to revise the indexing technology, which Google kind of people are doing, so that the problems which were there in the relatively old technology of indexing should no longer be an excuse. Now, as a court, today court may say, please do this. It is for you to find a way out of it. Let us remember that in the old Yahoo case, the court said that per day I will fine you certain things if you don't follow my order of blocking. I've given you a blocking order. Don't give me an excuse that it cannot be done. You find a way. And today, with the presence of AI engines, I don't know whether any technical organization can take it as an excuse. At best, they may take that I want more time. Remember what happened in the WhatsApp case also? They said we will not be able to track messages, but all of us knew they can track it. Only thing is some more investment may be required for that. So, of course, in the Ramdev's case, it was also a point that Google itself was distributing the information into multiple databases, one in each country. So when it had to be removed, they didn't know where to remove, kind of a situation was there. That was part of their inefficient technology at that time. And I hope that they are much more capable than what they are telling in that particular case. And going forward, any order of a court, if it is relevant that data has to be removed or de-indexed. In the case of de-indexing, we are not supposed to have the entire content in the Google server. We are only supposed to have a referential tag, whereas India Kanun is having the entire judgment. Okay, unless of course Google may be having Google Books, they will be having extracts. They may do so many things, but there's, if you look at our Data Protection Act, it gives an exemption to search engines. Now, therefore, it becomes necessary for us to define what is a search engine. A search engine is one which only searches on the basis of keywords and indexes, does not copy the content. I think a definition of search engine has to be given for our Data Protection Act, saying that it is a facility which does not copy, like India Kanun, in which case India Kanun will become a different entity, Google will become a different entity, and the kind of right to forget we are discussing, the rights of India Kanun may not be same as that of Google. Of course, in our moot court, both of them are being looked at as a single party, and one council is arguing for both. But in future, there may be a need to bifurcate that. Okay, let us leave it like that, because our idea is only to give some more clarity to the audience before they get into the moot court. The other clarification from legal side which we wanted was, what is this in-camera proceedings and what are the guidelines for in-camera proceedings? Is there any guideline in the judicial this thing for that? Ruchika, can you tell me something more about it? Mute.
Yes, sir. So see, the judicial system in India basically is more or less an open court system. This culminates actually historically, that is how the judicial system in India has been, you know, where even if you look at a panchayat system in villages, or where if I go back in history, you talk about kings who were holding courts, they were open courts. So the whole justice system in India has followed an open court system. The basic premise behind it, I feel, could be that it leads to a transparency, it leads to an accountability, which is much more important when we look at the democratic system. You know, so a free flow of information, and to make sure that the judiciary is functioning independently, I feel is important to have an open court system. So most cases in India are heard in an open court system. There's another reason behind it being that we have to spread awareness of law. People need to know how things are proceeding before the judges, and also if you see in a normal proceeding before court where there is any private person is involved who's not a public figure, public is not much interested in the proceeding that is happening, you know. So there is a kind of confidentiality that is maintained in itself, more because of the lack of interest, not because the courts entail such a thing. Whereas in case of a public figure, it becomes so well publicized, it's all over the media, and there's also something called a media trial happening. But all these things have not been prohibited by the law. There is no regulation, or there is no mindset where we say, oh, you should not be doing this, or this is incorrect in any way. So in what I'm coming from is that court records, court proceedings, they are all public records and they are public proceedings. So people have access to these proceedings, and that is how things have been moving so far. And there has never been an objection to court proceedings. Why are they public, or should be made confidential, except in cases where minors are involved, or these are matrimonial matters, or rape victims. So to safeguard the identity and to make sure that the victim is able to move forward in life and live with dignity, in these kind of proceedings, there is a provision that in-camera proceedings have to be done, and only limited people are made aware, and even their names are not used. Going to the popular Nirbhaya case, unpopular I would say, where though later on the details were leaked due to some error, but Nirbhaya is actually, it was a pseudonym that was used. So in these cases, there is a provision that has been made by the legislature, but more or less the courts follow an open court system. Now, what has happened is, now with the technological advancement, these proceedings have moved to the virtual space. And courts have been very quick to adopt the technological advancement because they want to reach more and more people, you know. So be it by way of live streaming of proceedings, making case details available on their websites, or even conducting proceedings virtually. So all these are making information more available on the net. So I feel it's never been about not having an open court system, because that is how it has been for generations and centuries in India. I think the issue now is about the ease of getting that information. Because earlier, if I needed an information about a case, I had to go to the court. I had to really go to the registry of the court, find out the judgment, or run through the publications of case laws to find the judgment. Now it is so easy for me. I just need to type a catchword, or maybe, just something that I remember from the case, and I can still find it so easily. So I feel it is not the question on the open court system, than it is about the accessibility of those that information and the case details. And I would again say that there have been exemptions made by legislature with respect to proceedings which relate to minors, or which relate to women, which relate to matrimonial issues. Even Right to Information Act has made an exemption for disclosure of personal information if it will result in invasion of privacy of the individual. So those kind of provisions are made. However, the open court system is what handles or takes care of most of the proceedings in India.
Okay, I will ask one question to Trupti also. That is, see, you spoke about the in-camera proceedings justified in the case of women and say children, Nirbhaya case you quoted. Now, should we consider that as gender-specific exception which we have to create? What if in a particular case, a woman is the accused or a criminal? Like in the case of Nirbhaya, you wanted to protect the girl's name, fine. What about the accused name? Should we protect that also as a part of the privacy? Whether they are acquitted or not is the next question. But before when the trial is going on, we say everybody is innocent until proven guilty. So should we say that this right to be forgotten, or this in-camera proceedings, or the privileges of only the women and not to the men? If so, how will you handle a case where a woman has committed a crime? Trupti, can you just tell me what principle should we follow in that respect?
Yes, so there are a couple of points before I come to that answer that I want to make. Starting with all of this coming from Article 21, even Article 21 is not absolute. It very clearly says that it is subject to due process of law. Now, coming to the next question of gender, now we saw in today's day and age, gender by itself is a very fluid term. There is a lot of noise about gender fluidity, about, the way people identify themselves. There are a lot of publications coming from international bodies, including the UN today, which is identifying everyone as a human and bringing it under the realm of human rights, because dignity cannot be gender specific or gender agnostic, technically. Now, taking from what Ruchika said, this is more a social issue, right? I mean, the justice system has been a four-pillar of society. There is a social angle and there is a judicial or a legal angle. There are many things which are okay legally. For example, live-in relationships. Supreme Court in 2005, gave it credence. But socially, there is still a certain, I would say a certain, I wouldn't say good or bad, but a certain hesitancy that exists with it. So, for example, Section 377 being struck down. But socially, it has to still move forward. So when it comes to gender or when it comes to protection, there is a societal angle which is very closely linked to, even if it is legally correct, whether it can be socially acceptable, or does it impact a person's right to live freely, and again, the way everybody perceives him. So it boils down to reputation. Now, coming to what if the accused or the respondents are also of other genders and they are not specific. When we see in cases of minors, sir, minor doesn't distinguish between whether it is a lady minor or a male minor. We just use the term minor. So same way, I feel that slowly the law will evolve to such an extent where if it is in-camera proceedings are regulated. They are only permissible by law. Under CRPC, as well as under Hindu Marriage Act, as Ruchika did mention, that there are certain kinds of situations where this can be used. Section 327 of CRPC is very clear that if it comes to national security, that is questioning of, let's say it's a trial involving some sort of a terrorist. Now, so it doesn't say women terrorist or a male terrorist. It merely uses the word terrorist because that could be sensitive. It could impact international diplomacy relationships. Therefore, an in-camera proceedings is permissible. Matrimonial disputes, which include personal details that have happened between a couple. There is no distinction in gender there, sir. In matrimonial disputes, either one can be the complainant or, the petitioner, and either one could be the respondent. So in such cases, again, in camera is permissible without really a regard to gender. Domestic cases of including custody of children or minors, I already mentioned, are gender agnostic. Now coming to criminal matters. Criminal matters today are identifying or protecting women because the law today is against for dealing with sexual crimes against women. We still have to come to a level where the law has to amend or evolve to identify sexual crimes against male members of the society. So today, when you look at all these sections, it says outraging modesty of a woman. It doesn't say outraging modesty of a person. So I think privacy is a derivative coming from other laws, and the other laws genesis itself, if they are gender neutral, privacy is following gender neutral. If they are gender specific, we are following gender specific. But slowly, eventually, post 377, with the sense of Supreme Court, sir, I think the gender debate will undergo a huge change, including most women enactments. Like most common act, which all of us in corporates know, is sexual harassment against women. We always get that, why is it not for men? But there is an additional layer of protection given by the lawmakers, by the society, because these are more vulnerable sections. So women, children, minors, disabled people, third genders, today are vulnerable. That is why there is additional protection. Privacy and inherent dignity affect them more. The consequence of an event has a higher impact on them from an angle of violation of their dignity and their reputation. I think that is my 2 cents.
Okay, thank you. Maybe the same principle will apply to the right to forget also. Now, I would like Mr. Lemay to answer one of the questions which has been raised by Mr. Prakash. He says that data in internet is also used in researches, and there is a reference in a footnote, okay, of the data. Now, which means that this kind of data which we are now disputing as the title head of a, you call it as a cause list or something like that, in a judgment. Same issues will also be there when references are given in research documents. Now, should right to forget extend not only to India Kanun and Google, and all, but also to wherever references are there? Of course, if that reference is taken from Google after it has been redacted, then one may not get the exact name. But let us come to a situation where partially the information is available through research institutions directly, or let us say it was already made public at one point of time, and it is part of the research documents. Now, how should this right to forget apply in such cases where for research you collect that data?
So that's what I mentioned in my opening remark, that if somebody has captured that particular information and thereafter court passes right of erasure or right to be forgotten, then there will be practical problems in proving that particular data, that this data was existing or not, because intermediaries or search engines will be made liable if that data is made available after the order is passed. So this is what hypothetical question we are considering, because whatever is happening will happen only when law will be passed. So we are debating far ahead of time. Presently, there is no such ban on, no such blanket order for right to be forgotten or right to be erased. What previously Mr. Kudandram mentioned regarding Google matter, Ramdev matter, there the court order says specifically that that particular petitioner should come up with whatever possible links they have, and those links will be de-indexed by the Google. So responsibility was cast on petitioner also to provide the locations where that particular data would have been available in their knowledge. So this particular question is very interesting question, but since we don't have any legal framework available, and what we are trying to do is to give our own vision to whatever will be possible in future if right to be eraser or right to erase will be a reality. So this will be the situation where service provider will say, I have erased everything, but if somebody has copied previously, that is not my responsibility. So it is a two-edged sword right now, that it may be used by the, say, whoever has stored that particular data to book those particular search engines or those particular intermediaries, because intermediaries may not be knowing that wherever that particular information is residing, from where that particular information is captured. So these situations will be definitely be dealt as per whatever are the facts of that particular matter. Because what we say many a times, it generally happens, we recall something, but we say, I don't exactly recall the name, but something somewhere it has happened. So that could be the situation where this defense would be available, that yes, it had happened somewhere, there is some reference in this particular citation, but we exactly don't know where or at what place it has happened. So whenever these sort of issues will come, certainly there would be some set of, say, allied facts available in that particular situation. And what we understand from judicial or legal system is that everything is fact specific. So whatever will be the facts at that point of time, only those facts will be taken into consideration. So that is my reply to what Mr. Prakash asked.
Now, actually, you have added one more challenge to the technology people of time stamping when the information was picked up, and also time stamping when it was deleted or something like that.
Exactly.
Tomorrow you should have an evidence to say that it was deleted as soon as the court gave its order or something like that. And subsequent things, of course, I am not responsible, something like that. Okay. Prakash, do you want to add anything more to? Yeah, please go ahead.
Thanks, Navi sir, and thanks, Dr. Limaye. Yeah, exactly. Each of these has to be handled on case-to-case basis and based on the evidence. And yes, if the data has been copied in a research and the date of accessing the data is actually before the court has passed an order, then obviously, those are things which we will have to handle, or rather cross the bridge when it comes.
Anyway, record that complication, technology-related complication. Everything is not magical. It will not happen. Then tomorrow, if an objection is raised that the intermediary did not do that, then court also should be reasonable in accepting whatever explanation is given. So, exactly. You have got anything to say? Any questions, Subraidu? You can unmute. No.
I have a question, sir, to Abhay Bhatt.
Yeah.
See, we are talking about technology not able to curb, at least in future it will do. And Trupti is telling that sociologically we are open court, so also Ritika. The problem is the earlier communication system was totally different. I have seen in the villages, in the panchayat, even matrimonial issues are openly discussed because it has limited liability to be spread. Today, when you make it in camera, it has certain stipulations where it was controlled the way it was done. But now when it comes to a virtual world, now is it not the time to look into the various informations or various types of cases and whether it can be reported or not reported, or whether it is virtual or closed courts? All those things have to be redone, have to be given a relook, and only if the technology could provide that kind of protection, then they will have an ethical approach. They are only to choose those cases and report. Others they can give away. Don't you think that is the way we can protect the dignity of the persons? That's how I feel the present
one
situation.
Point, adding to what Mr. Kodandaram said, even if technologically you can do it, today you mentioned that you said globally block this particular information. So what is the strength of a judgment coming from a court? There will be a jurisdiction issue. Today, if a court in Kanpur passes that, why will somebody in Spain follow that, sir?
Perfect. Sir, here the
That's
biggest
exactly what I feel in the social, this one now, cyber technology has no barrier at all. It has no respect for sovereignty of the nations.
Yes,
So now
internet has
sovereignty, how it can
transcended.
be re-established? Don't you think we need to have some kind of technological thing where universally we agree? When we are universally agree to communicate to each other, is it not a discipline that should come out or ethical standards to be maintained by every country? Otherwise, we may not entertain communication from those countries. Something we may have to relook.
Not
Otherwise,
only
our
that, sir,
sovereignty itself is in big question. Today, you are talking about cyber influencers and cyber terror that is being spread. Why should we become pawns to others' reactions? That's the biggest issue now. I think there is
absolutely.
something to be done in this regard. That's what I feel as a
Also,
layman.
sir, the
because I'm not
grounds.
technically
Also,
not
sir, the grounds. For example, our what we identify as sensitive, let's say matrimonial matters or rape victims, as we were discussing in camera, the same thing may not be sensitive information or sensitive in another country or culture. Now, when you tell that you have to follow this basis, the law of the land, sir, in internet, where do I go looking for law of the land? Where is the territory? Because law by nature is territorial, sir. Every law says within the territory of so-and-so. So I think while technology, I know Mr. Abhay will, give his expert views on this, but legally, I do see a challenge. I agree with you, sir. And I'm saying this after 26 January, where we are very proud to be such a democratic nation, that I don't know how it will pan out following legal orders. Similarly, if we get from another foreign country, tomorrow, if a court somewhere in Saudi Arabia tells us that this needs to be changed, what is the validity for us?
So Trupti, the challenge over here is, there is a two aspect of it, and it is the technology and people, where people have to ensure the process and understand the system. Okay, where, people should be driving the technology. Now the era has completely become different, where the technology is now driving people. And there where people say, technology is there and I can't do anything. But it's not the way. You need to have a control of your data, which a people factor only can understand. So if you ask me, where people ask me, Abhay, what is now still a good solution, a cloud or an on-premise? I still say it's an on-premise solution is the best one, because I have a control of my data. Okay. It's not that I can't control in cloud. I can go and control in cloud, but then I should go and ask those cloud providers, the big giants, AWS, Google, okay, Azure, you tell me the boundary of my data. And believe me, none of the small players or even the big players goes and ask them, sir, you tell me the boundary of the data. Because data is something which is going to, has to reside on some physical disk. That physical disk will have some storage. That storage has to be located in some data center, and that data center has to be in some area. So it's not that the data cannot be tracked, or it is the human tendency or the human factor, or it's the willingness of people to go one step ahead and go and ask those questions. Okay, and sir, with respect to the consistency, even if you look the GDPR which is there with the European states, okay, the European countries have still not been able to have GDPR in a consistent manner across EU also, because of some national derogations which are being provided, provision that has been given to them. So if you ask me, having the consistency mechanism throughout the country or throughout the world is a big challenge, depending upon the whole local laws of it. Technology is there, but it has to be controlled in a fashion by human. If it's the technology, if it drives human, then it is really next to impossible.
Thank you. Thank you. Unless Subraidu has got a question, we would be closing this session so that we will be opening the next session. Subraidu has raised his hand, so just give him an opportunity. Yeah.
Sorry, inadvertently I think it got it. But anyway, I think I once again reminded of the remark that in the congressional hearing, the Meta executive told the people there that when you have to know where your data is, right? If you don't know where your data is, the question of pulling it back will always be incomplete. As he classically said, I have a bottle of ink and I poured it into a lake. Right now, you're asking me to pull that ink out of the lake back into the bottle. Right. So I don't know whether that kind of a technology can ever be invented.
Okay. I will put one thought in your mind, not for immediate answer, but for later, a philosophical question. Where does data reside? does it reside in the hard disk, which is located in a physical place, or does it reside from where a person can access it? In the sense that if I can access the data from India, even if the hard disk or cloud is in USA, should I consider it as data residing in India because the access is available to an Indian resident? Or should we take it as the zeros and ones lie in a particular hard disk? This is a philosophical question which has to be interpreted. Whether data does not reside in the hardware, it resides in an ability to interpret the zeros and ones. This is the theory of data. Where some other time we will discuss.
Sir, I think there was a GDPR ruling also here. If there is a GDPR ruling which said that if the data can be viewed on screen outside the country, then it amounts to a data transfer.
Correct. That is correct. So access is more important than physically where the data center is present. Because if you agree on something like this, then taxation and other things also will apply. Now, data has got a value, and where it resides, that country will say, I will tax Amazon assets or something. So there are certain unsettled issues there. And in terms of law enforcement, of course, what is relevant is from where it is accessed. That is where I want to control. Okay, we'll leave that for the time being. That's why I said it's a philosophical question. Technology people may not immediately accept that, and how to implement that is a separate this thing. Jurisdiction can be solved by redefining this residency of data does not depend upon the physical location of the data holding device, but from the ability to access the this thing. If we define it like that, then jurisdiction to some extent gets resolved. I think this is time for me to thank all of you panelists. I'm sure our registrar is already worried that we have exceeded the time, but I think that is fine. Anyway, thanks all the panelists for taking time to explain these things. This was necessary for people to actually follow the next moot court decision. So let us close this panel discussion here. Thank you. Yeah, Manju, you can take it to the next. Now, for this part of this thing, Kodanram and myself will try to sit as if we are judges. Okay, let us assume that role, or you can even say it's like a tribunal, doesn't matter. And we are having before us the discussion which has emanated from a slew of appeals to this Kerala High Court verdict. This Kerala High Court verdict has suggested that we provide this right to forget in certain cases, that is the matrimonial cases. So beneficiaries of that case is one party. It has rejected the right to forget for another set of cases, which are all the criminal parties. So there are people who are representing those criminal parties and appealing against the Kerala judgment. We also have these publications, India Qanun and Google, who are trying to justify their right to publish. Okay, and they want to publish not only in the case of criminal these things where there is no problem because the court has refused to give grant right to forget, but even in the case of matrimonial cases, they have a right to publish. In fact, I think one of the cases which have been mentioned in the Kerala has already had a detailed media trial. I think that medical doctors and the mother and daughter that already had been exposed in the media, and media people always would like to take advantage of information which is current, and they are now trying to justify their rights. So these are the parties which are there. And in addition, we have a group representing the government, you can say Ministry of Information Technology, because everybody is looking at them to ask them, do you have a law in this particular these things? Or if you have something, can you explain? So these are the people who are present here. And I think Ruchika will perhaps explain these 4 teams, and then perhaps we will start discussing the court proceedings. Okay. Yeah, Ruchika, just you have to give a brief distribution of the teams who represent each team, and that is something which you can do it actually.
Sure, sir. Thank you so much. I would start by saying that this is just an enactment of a fictional case that we are running. We have taken an inspiration from the Kerala DB judgment that Navi sir had briefed us, everyone about in the beginning of the session. What we are doing today is we are presuming that this matter goes in appeal before the Supreme Court, and where the judges are Navi sir and Kodandram sir, and then we have various teams who will be representing. So I will be representing the appellant. These are the appellants who've come in appeal from the Kerala DB judgment, wherein we are asking the court to give us relief, which was not given by the Kerala court. Team number 2 is represented by KLE students Neha and Vaishnavi. They are representing the parties which were before the Kerala DB as with respect to the matrimonial matters and there's other sensitive matters. Team number 3 is represented by Dr. Limai. He is representing the search engine as well as the publication, the case publication website. Team number 4 is represented by Tripti. She's representing the state. And Abhay is the technical expert who will be assisting the court in any technical query that the court has.
Okay, let us invite team 1 to present their arguments.
Sure. So, Your Lordship, thank you for giving us this time today. Your Lordship, I would like to draw your attention to the observations of this Honorable Court in the landmark judgment of Justice K.S. Puttaswamy and others versus Union of India. To live is to live with dignity is one of the statements that were made in this judgment, which are very close to my heart and also the core of the matter before you today. The right of an individual to live with dignity is paramount, as is equality between human beings. Privacy as a right is protected under Article 21 of the Constitution, which guarantees life and personal liberty. Privacy not only includes the preservation and sanctity of family life, marriage, procreation, sexual orientation, etc., but also connotes a right to be left alone. My ability to control the vital aspects of my life and my personal choices. Technological changes in the past decades have given rise to concerns which were not present earlier. Technology has opened the world around us and has created a virtual public space, thus making the identity of an individual digitally immortal, which means that information of an individual, which is once available on the World Wide Web, is there forever, even after the death of an individual. The online presence of data permanently raises new questions regarding right to privacy. The appellant's right to exercise control over their personal data has to be able to control, and to be able to control their life would also encompass their right to control their existence on the internet. The appellant should not be profiled for time immemorial by all and sundry. The personal and private information of the appellant that remains in the digital space permanently invades their right to privacy and right to be forgotten. By virtue of this, the appellant loses control to decide which information about themselves will be disclosed to whom and for what purpose. The right to be forgotten is a right to forget the past and live in the present. For this purpose, I would like to draw your attention to another right, which is the right to rehabilitation. Right to rehabilitation is a right that existed prior to the digital age and refers to social integration, subsequent reintegration, subsequent to judicial conviction. Legislation of countries like United Kingdom, France, United States, etc. provide for erasure of conviction records subject to fulfillment of certain conditions. Unfortunately, the same is not present in the current scenario in the Indian context. Even Article 17 of GDPR, which is looked at as the most comprehensive regulation on data privacy, recognizes right to erasure, which creates an obligation on data controllers to erase links to third-party websites. It also provides for erasure of data when it is no longer relevant for the purpose for which it is originally processed, or where consent is withdrawn. Now, this kind of a right gives my client, the appellant, a relief, some kind of scenario where he can live his life with dignity. Whatever has happened in his past can be forgotten and he can move forward in life. The right to delisting, right to oblivion are also facets of right to be forgotten in the digital context, which include right of the individual to request search engines to delink web pages containing personal information about them. The appellant is a private person in whose life the public does not have much interest. He is not a celebrity. He is not a public figure. Then why should their personal data be allowed to appear in the public sphere? The appellant should be allowed to erase memory related to past events and build a future with sincerity, good deeds, and move forward in life. Thus, it is imperative that the fundamental right of the appellant is upheld and their personal data as made available by way of case title or body of the judgment be redacted and the judgment also delisted from any search engine. Without this, the appellant will not be able to move forward in life with dignity. That is my prayer before your honorable court.
Dear counsel, I have a question, sir. See here, you are talking about if a criminal is held as a convicted, why it should be removed? And even when you look in the past also, you take from the Valmiki, we talk about him a convict at that time, and he has rehabilitated. How it can have rehabilitation can trouble in the present world? We have to know the past and build the future, and whether he has improved or changed himself is also visible. Both of them are transparent matters. How this can influence there at this present juncture? Can you explain?
Sir, unfortunately, the society gets prejudiced by his past. And even if years and decades have passed since he committed the crime, he's not given an opportunity to be rehabilitated. And even in cases where he's acquitted and there has been no order of conviction against him, just because he was at one point of time an accused before the court, there is a prejudice against him and he's not getting an opportunity to move forward in life and to live with dignity. He's always looked at as a convict. He's not even looked at as an accused. And because of this, and for how long does he have to bear the consequences of a mistake, even if he did a mistake, or by an error of somebody else, or an error committed by somebody else where he was accused in a matter and subsequently acquitted.
Then
but
you
he is
agree.
still facing the consequences, sir.
Yeah. Then you agree
so
for
how long?
acquittal cases and convicted cases, we need to have formulate separate decisions for
Sir,
that,
even if
whether it is convicted or acquitted otherwise.
No, Lordship, I beg to differ, because even in case where a person is convicted, for how long he has been convicted, he has bore the consequences, he has completed his punishment. Now we always say that it is not to punish the person, it has to reform the person. The criminal justice system in India also says that there has to be reformation. So if there is no chance for the person to be reintegrated in the society because he is always looked at with prejudice due to whatever has happened in his past, then how will he move forward in life? And where is the question of reintegration and living with dignity?
Then by delisting, do you assure that rehabilitation will be surely done, or he will not get into the past acts again? So that
Lordship,
the society
an opportunity. Lordship, an opportunity is what we are praying, because so far that opportunity is not afforded to him. And for every act that he has to commit in life, there is a prejudice against him. So there is no equality as well.
Thank you. Thank you for your forceful argument, madam. Let us try to see what your respondents have to say. Of course, if we agree to your contention and agree that right to forget exists, it means that publications like India Qanun and Google will have to de-index and remove the content. Now, therefore, we have to listen to the arguments of that side and try to understand if they hold any reservations about the points raised by council on the other side.
Your Lordship's counsel appearing for the state.
Yeah, Mahendra Lemai, I think, can make appearance.
Yeah, Lordship, I am appearing for the search engine and the publishing website. And thanks for opportunity. I want to extend this particular argument from the appellant side that we have seen in
just 1 minute, Lemay. Trupti, are you also making any argument on behalf of what Ruchika said?
Sir, I'm for the state, so I am responding to the contentions she has made as rebuttal, sir.
Contentions of?
Your Lordship, the first issue that is being argued by the appellant is right to erasure and right to be forgotten as fundamental rights under the realm of privacy. And I'm representing the state government authorities.
Okay, let's hear the commercial respondent actually, who are directly affected in terms of their business. Okay, then we will come to the state's views about
Obliged,
it.
Your Lordship, much obliged.
So, Lordship, as we know that India has adopted open code system. So whatever happens in that particular code should be known to as many people as possible, because that will give accountability, I may say so, on judiciary also to perform diligently and expeditiously. So when India has adopted open code system, we should not be afraid of publishing these particular decisions whenever possible. There should not be selective representation of these sort of decisions, that this decision should not be published, this decision should be listed, this decision should be de-indexed, etc. Because we as a commercial organization have every right to carry out free trade and business. We have this fundamental right to carry out free trade and business. And when India has adopted open code system, all the decisions which are free of cost, we have this particular right to make business out of it, because there are no charges for this sort of publications to be republished by our search engines or our publication house. So there is no tax we are required to pay to, say, any judicial authorities, why you are using our judgments, etc. So by ordering that these judgments should not be published, these judgments should not be say made in open space, that hampers our right to carry out trade and business. That is one contention. Another contention is that technically it will not be possible for us, even if court directs that this judgment should be kept in camera, this judgment should not be published, because till the publication of that particular judgment, whatever proceedings are going on can be published, can be reported. There are orders of the court on particular day, interim orders are there. So those orders will be already available on our websites or on our publication house. So how we can act in that particular situation, that after entire trial, court directs us to remove entire proceedings, because by that particular time, these proceedings would have been gone public and many people have copied. So if that particular thing happens, again we will be held responsible, and we act as per Information Technology Act as an intermediaries. And when we see what are the provisions on intermediaries cast under Article 67C, that is, intermediary shall preserve and retain information as may be specified for as such duration and in such manner. So reading this particular law in negative manner, if it is ordered to us that you must delete that particular information in so and so time, and technically if it is not possible for us, it will be detrimental on us and unnecessarily will be required to pay hardships, because there may be some fines by court, for not following orders. It may be termed as a contempt of court. So we don't want to put ourselves in that particular situation. And that's why we want these particular decisions or whatever happens, if it is once published in open domain, even if the interim orders, etc., it will not be our responsibility to remove entire things. We will try our level best, because we are also part of this country. We are also part of respect judicial system of this particular country. So whatever best possible for us, we will do, but we should not be held responsible if some information is available by mistake on some of our say parts or some of our search engines, etc. So that is my submission, that we should not be unnecessarily troubled. Whatever order honorable court gives, we will try to follow to the extent of 100%, but we should be protected from our intermediary liabilities and responsibilities also.
Mr. Kodanram, you have any question?
I have a question to Limai. See, you are talking about others do not have an absolute right. Now, how do you propagate yourself to the absolute right, and that to the technology where you have no control? You want to explore the information, you can't control it. Is that the situation proper? Is it proper for you to say that it is equitable and for you to be fair, to have absolute rights? Is it correct? Can you check up how you can do about it?
Sir, my humble submission is that if we remember the case of Apple, when terrorists were killed and Apple was asked to decode that particular information through its phone, and the argument was made in federal court that it is not possible for us technologically also to decode that particular Apple phone. So technology is such that creator means we have this particular security issues inbuilt, that whenever we create one particular system, we don't want to break that particular system. So once a decision is published on our system and we don't know the exact locations where it goes, you may say technologically. So that's what our submission was. Whatever is made in our knowledge, that at these locations that information is there, you remove that particular information. We are giving our undertaking that whatever links you direct us, that remove those particular links, we will be certainly obliged to do that particular delisting or delinking those particular links. But it is beyond our control, because technology is such that you never are sure what could be the manipulations or different versions of technologies which may come up in future. So whatever is brought in our knowledge, we will certainly obey the directions of the court, because technically some things are not possible which are beyond our control.
When links are given, costs are involved for searching it and giving you that. Who is going to bear the cost?
So if you are getting hampered, if victim is getting hampered, it will be responsibility of the victim. But why we should bear for that? We are free search engine. We are not charging anybody. We are providing service, and it is ultimately an open court system. We are assisting court to facilitate its or publicize its judgment in a wider perspective. So in a way, we are officers of the court also. We are extended hands of the court. We are propagating these particular judgments of the court. So why we should be taxed, my honor? It should be the responsibility on the person, victims who want that particular identity to be delisted or erased. So our submission is that whatever directions are given to by the honorable court to us, we will be obeying those particular order. So we will not be doing anything extra in that particular situation. Let the court direct us. These are 1, 2, 3, 4 links. You have to remove it. We will certainly be obliged to remove those particular links, Lordship.
Don't you think it is inequitable when the victim is again pressurized to get the links, where he may have access or he may not have technological ability to find out? Then it will be a kind of a justice denied to him, is it not? And victim is already harmed.
Absolutely not, sir. Why we should be taxed unnecessarily? For the
we have taken your views on this. We have also heard the appellant's views on behalf of the victims. Now you say that you have your right to information, because of which you would like to publish that, and also technologically there could be some difficulties. We have already heard from our experts that technological difficulties may not just be continuing in the new era. That will keep it aside for a later time. But I would like to hear the views of the government of India on because they are the custodians of the intermediary regulations. And now one of these intermediary is saying that he is not in a position to meet the requirements of partially the court which is already ordered, or whatever they may like to do. Now, we would like to know the views of the government of India on how they see the conflict between the victims on the one side and then the commercial organizations on the other side. Counsel for the government of India.
Much obliged, Your Lordships. Counsel appearing for state. First point that I would like to draw Your Lordship's attention to is that everybody who's discussed in-camera proceedings and mentioned that there is a certain right to privacy that is coming with it. So one is at the discretion of the courts. Secondly, in-camera does not just mean having it having the proceedings conducted in a closed room, but it also prohibits publication except by permission of court. So in that realm, unless the law provides for it, as a government body or as an authority, we cannot go ultra vires what the law says. Now, the law has very clearly set down what are the categories where a certain protection of identification can be given, by giving options like in-camera, which also is at the discretion of the court. In fact, may I draw your attention, this very court, the Honorable Supreme Court, very recently rejected the claim of the Tehelka editor-in-chief for in-camera proceedings in a rape case. That was rejected. So, Your Lordships, it is not just about sensitivity or who are the victims or what are the rights. It is also the matter at hand and what is the national interest associated with it. And both Article 21, which give right to privacy, and in-camera proceedings, they all come with an exception of, sir, it has to be at the discretion of a power. It is where due process of law should be followed. Now, my second submission, Your Lordship, is right to privacy versus right to informational privacy. Now, what my learned counsel brother has said, mentioned appearing for the search engines, that there is a commercial associated with it, and it is not their responsibility because they are only intermediaries acting under certain guidelines given by the state, is only talking about informational privacy. So right to privacy, which is inherent to dignity, whereas in informational privacy, it is right to access of that information that is available beyond what the powers of this government are. How do you exercise that? By way of technology. So essentially, there is a bifurcation created in the way information is treated offline and the information is treated online, Your Lordships. My humble submission in this regard is that people who are coming before the court, Your Honor, when they submit to court proceedings, they are very well aware that court records are matters of public record. People who are consenting in other enactments, commercial organizations where you take consent to provide a certain service to them, the law under Puttaswamy judgment is very clear. It has to meet three requirements: legitimate aim, proportionality, legality, Your Lordships. If these are justified, then a right to privacy is not an absolute right, and it can be violated, or not violated, rather diluted, Your Lordships. Pardon me for using the term violated. It can be diluted vis-a-vis the victim in the name of national interest. So, Your Lordships, in a liberal democracy, every public institution is built on public reasoning. Public reasoning endorses collective affirmation of a larger common good. And as state authorities, Your Honor, our lookout has to be larger common good. The social and ethical problems in relation to digital immortality, as mentioned by the counsel for the appellant, and artificial intelligence, machine learning, online search engines, etc., which can identify the data stored through algorithms are subject matters of debate across the globe, Your Lordship. This problem essentially stems from this new era of technology due to lack of legislation as on date or regulation on controls to ensure privacy with balancing the state interest. The intersection of privacy and technology has become a challenge to the judicial administrator as well, Your Lordship. The courts are attempting to keep up with advancement of technology, as we are all very well aware, as mentioned even by my appellant, by the counsel for the appellant, that court system is an open system. We always thought that it was setting the benchmark for societies to follow. It is the way the social fabric is woven. Now the courts are attempting to keep up with the technology world, which is an online society, which is growing in a very different manner. Now this brings some change. For a good and just social system, credibility and people's confidence is something that is very important in a system to include public interest, national security, which are extremely critical, which the government has to protect and ensure, Your Lordships. Public interest versus private interest is a constant struggle, especially given the pace and reach of technology today. In the larger ecosystem, policy making, justice and law enforcement integrate with the socio-economic, political and cultural aspirations of the society and the state, Your Lordship. In such a scenario, courts also hold factual information and they cannot claim a monopoly over all this data. They would require to alter their approach because this data is available with the judiciary, Your Lordship. The question is whether it can be made accessible to everybody through search engines, which are appearing as an argument that it is they are an intermediary to this. The modern government will have to solve many issues pertaining to this sort of a public administration issue. Now, there are different stakeholders which come into this, Your Lordship. If I may just add a few more points to this, there may be restrictions on how to access data. There may be regulations.
Madam, now, as far as the government is concerned, is it having any objection to the request of the appellant being agreed to? So, please give.
Yes, Your Lordship, it would be detrimental to public interest. That is the point I was making, Your Lordship, that if complete erasure is given, then it would be detrimental to public interest and national security.
So you are against the agreeing to provide the right to forget for the appellants.
As the law stands today, Your Lordship.
As last, okay, we are looking at here one set of appellants who are part of the Kerala the subject case, which all are people who were involved in some kind of a criminal accusation, even though they were perhaps acquitted, or some of the cases were actually withdrawn or compromised or something like that. They were not declared as criminals, but it was stopped somewhere. Okay, so those are the kind of people. We will separately look at what the government feels in respect of the other set of victims. Then we'll come back to continuing our discussion. So we'll now look at the team of counsels who are representing the cases of those matrimonial cases where, though they have the case, judgment of the court has been in their favor. Now we are seeing that these publications are objecting even to that, and therefore let us listen to their views, and then we'll come back and see whether the government has got one view for these criminal kind of cases and another view for this, or you have a consistent view for both. Is it okay? Yeah. Now, on behalf of this other team, Vaishnavi, you are presenting your argument.
Yes, Your Lordship. Your Lordship, firstly, am I audible and visible?
Yes.
Yes. Your Lordship, thank you for giving me this opportunity and taking your time out. Your Lordship, humans possess freedom and liberty to live with dignity. While R. Rajagopalan versus State of Tamil Nadu and People Union for Civil Liberties case discussed right to privacy and gave an emerging definition, but the question still stands as what if this individual comes in conflict with the rights of an institution like marriage? The council would like to draw attention to Section 22 of the Hindu Marriage Act 1955, which states, except the judgment of the court with the previous permission of the court, no proceedings of the court shall be published or printed. Section 22 of the Hindu Marriage Act 1955 also reads, proceedings to be in camera and may be printed or published. The clause 1 says, every proceeding under this act shall be conducted in camera, and it shall not be lawful for any person to print or publish any matter in relation to any proceedings except the judgment of the High Court or the Supreme Court printed or published with the previous permission of the court. The section clause 2 also says, if any person prints or publishes any matter in contravention of the provisions contained, he shall be punishable with fine, which may extend to up to 1,000 rupees. In family, matrimonial, child custody, and adoption matters, if the legislature had already intended to protect the privacy of the parties involved therein, merely for the reason that it does not in other laws.
You are on mute.
Vaishnavi, you are on mute.
Lordship, am I audible?
Yeah, now it's okay.
Okay. The court cannot hold that the protection to the right to privacy does not exist in such matters. The protection accorded to privacy in matrimonial, family disputes, or custody or adoption in a slew of legislatures signifies that open justice principles is not in contemplation of the legislature in those matters. Thus, the council prays to let alone the matter of matrimonial, family dispute, custody, and adoption being published or printed for the main purpose of the right to privacy being upheld, which also includes to live with dignity. My co-counsel would like to take forward. And thank you, counsel. It was an honor to be arguing in front of the Honorable Court.
Neha? Unmute. Yeah.
Your Lordship, I'm sure you would strongly agree with what I'm going to say further. Family is a very private thing. It's a big responsibility, and what's happening within the four walls of a family or within the four walls of a house is not anybody else's business. Now, family matters with regard to matrimonial issues or child custody or rape are very sensitive in nature, and they're very private. Each of these issues are to be dealt differently in different cases, and putting it out publicly is not really fair or right to the parties themselves. It is a matter of somebody's personal choices, decisions, and life. Now, right to privacy as a fundamental right is a new concept, and it's walked into India very recently. Now, just because the right to privacy is not mentioned in any particular law, like that of matrimonial cases or family-related matters, doesn't mean that right to privacy is not a part of any such matters at all, or it doesn't exist in such matters. Now, the privacy awarded in family issues and matrimonial disputes is clearly signifies that open justice principle is not in contemplation on the legislature in these matters. The denial of open court function in such matters is recognition of protective rights of the parties regarding their privacy. Keeping this in mind, we can say that the court shall not publish details of the parties to identify the cause before the court if the party or the parties desire so. The learned counsel Shri Vipin V. Varghese, appearing for the petition, had filed a writ petition approaching the court, seeking relief, invoking writ jurisdiction to conduct a marriage under Special Marriage Act, which never materialized in spite of this court granting itself to solemnize marriage with a person who resides in a foreign country under the Special Marriage Act. But according to the council, the Google search engine exhibits the name of his client along with the links of the judgment delivered by the court. Even though this matter did not directly arise from the family court jurisdiction, given the fact the court was invoked to solemnize the marriage, such matters on request of the parties, the registry shall mask the names and details of the parties, recognizing the right to privacy concerning matrimonial and family matters. Similarly, in this case, the writ petitioner approached this court on an earlier occasion in a dispute concerning to custody, where the court had to look into the right to privacy of the parties concerning the family matters.
Okay. We will have to go back to the government council. Government council is present.
Yes, Your Lordship.
Yeah. See, now the arguments are being put by two sets of people. Now, from the point of view of the government stand, now, do you think the court should take a view different for the two categories? For example, now when we are talking of right to forget, we are really talking of suppressing a factual thing which has happened some time back. Okay, whether it's good, bad, who is affected, that is secondary. Now, first of all, there is a fact. Now we are discussing whether the fact should be suppressed in certain cases, not suppressed in certain other cases. It could perhaps lead to an argument of discrimination also. The question of proportionality needs to be weighed in every thing. So these are the issues which the courts will have to look at in every case of such nature. So we would like to know whether the government is contemplating any specific clarification on this in whatever laws they are proposing. As we find that in the latest draft law which the government is trying to propose, there is no mention of the right to forget. Can you just give some views of the government, why the government thought that right to forget doesn't require a specific section as it was in the earlier version? Do they think that right to forget and right to erase are both same, therefore there is no need, or that they don't want the right to be forgotten as a right at all? What is the government's position on this?
Your Lordship, firstly, the way it has to be viewed by the government is at all times ensuring that it is playing within the law given. Now, within the law given, Your Lordship, right to erasure and right to be forgotten are stemming from right to privacy. In fact, the government of India had announced the National Data Sharing and Accessibility Policy in almost 2012, Your Lordship. Now, in that policy itself, this informational privacy aspect, as Your Lordship rightly mentioned, a fact that has happened. Now, that is already there, somewhere recorded in some manner. Whether that fact that it has happened can be accessed by anybody, everybody at any point in time, even generations or years after it is over. Now, Your Lordship, that is an internet control. The way the law stands today, to the extent where there is a sensitivity involved and what can be protected, there is not even a right to be forgotten. There is no right to even publish that, Your Lordship. As I mentioned under section 327 of CRPC, even publishing requires a court permission. Now here, on one side, there is an issue of you can publish it, but how do you regulate the dissemination of information beyond a certain point? And how long will that information survive in public realm? Now, this is a question before the way the new law has to look at it. But before that, the rights of the people versus the public interest has to be established, Your Lordships. Only then, how do we go about it will grow as, just like with any law, Your Lordship, it comes by way of precedence. Any law on day one will not have addressed every gap. It grows, and by way of judgment, slowly, these mechanisms come in place. So, Your Lordship, by virtue of this policy, there was an intent of data sharing and accessibility to be regulated, Your Lordship. Now, how that will play with the current bill is something that will be discussed in subsequent stages.
Data sharing and accessibility, was it something to deal with personal data, or was it meant to address sovereign data?
No, Your Lordship, it was coming from a court regime. It was by the Informatics Center in compliance with Open Data Policy of India to have an open data platform that people could find certain information. The objective of this policy was to have citizen engagement and community participation, Your Lordship.
That was for making the information available, no?
Yes,
The
Your
data
Lordship.
policy was actually making the system available so that there is no need even to make a claim under Right to Information Act. It should be already available. Was it not the contention there?
Exactly what I was trying to emphasize, Your Lordship, that this was for information which is already available, but to be, how it can be accessed. Now, the question we are raising is there is certain type of information which you cannot even publish, Your Lordship,
No,
which
say
is in camera, cannot even be published. So where will you even make it?
In a particular case, if the court takes a view that this does not require publication, that is a different aspect that the court will take a view on that. Now, where the court has not made any such kind of a ruling, I'm asking, does the government have a reason either for law enforcement purposes or for the public interest in terms of archival of interest on a reliable basis? See, what is the use of having an archival where 10% of the information is redacted and nobody knows what is right or what is wrong? Then if you create a history of the nation based on the 90% of the information, then are we not trying to distort the history of the nation is a question which the community has to decide. Now, let us listen again from Dr. Limay that whether as representatives of, let us say, a publication, let us look at publication at this point of time, not necessarily as a commercial entity, but as the fourth pillar of democracy, responsible for placing reliable data in public hands. So that if a person has committed a crime earlier and he has been acquitted, fine, that is part of life, and we all will say that in case of further dissemination, don't talk only of the negative aspect. Whenever you talk of a negative aspect, talk of the fact that he was acquitted. He was accused but acquitted. So as long as the news medium ensures that no unfair, one-sided view is provided, in a situation where a person was accused for some time, people were not happy with him, his reputation was bad, but after some time he was perhaps acquitted. There are many such cases where people have come back. They have many of the ministers have left the ministry and then come back. So I think this is where the news media should choose whether they are only purveyors of data for the purpose of making money, or they also have a social responsibility. And if the court tomorrow agrees that right to forget should not be given, and let us give the responsibility to the news agencies to actually responsibly handle the information, are they up to that kind of taking up responsibility? Yes, Mr. Lemay.
Lordship, first I should make my stand clear that I am representing publication house and the search engines. So our basic responsibility is to publish whatever facts which are available in court proceedings. We are not distorting the facts. So our interest is to publish whatever proceedings has happened before the court to the public, to more forward that particular information. But I thank Lordship for giving me opportunity and asking some additional questions regarding media. So I will try to defend media, but first I will quote one of the recent arguments by Honorable Chief Justice of India in famous case of rejecting Election Commission's plea for banning media to publish court orders and proceedings. This was the recent case where EC, Election Commission, objected for publication of some media. And here Honorable Supreme Court Chief Justice has said that the media has an unfettered right to report exchanges during the hearings, and they rejected the EC plea for banning those particular judgment. So we are in a strict sense, whatever proceedings are happening before the court, we are publishing those particular information. But Lordship, as far as media is concerned, we genuinely share your concern and we consent those particular concern that there should not be unnecessarily media trials unless the matter or till the matter is sub judice. We as a responsible society should not encourage this particular media trials. But Lordship, unfortunate thing is that we media are reflections of the society. So society needs this sort of media trials, and that's why we conduct this particular, means some media conduct this particular media trials. So it is very wrong on part of media till the matter is sub judice to pronounce some verdicts or to pronounce some own reactions on that particular incident. But we as a responsible intermediaries or publication house don't indulge into these particular activities. Neither our publication house provides any our expert views on the judgment or commentary on that particular judgment, whether it was good or bad. We only publish whatever is the fact, whatever is the verdict, whatever is the outcome of that particular situation. But Lordship, we surely respond or respect your concern that unnecessarily media trials should not be carried out, and we do consent and we do affirm these particular views that unnecessarily media trials should not be a part of responsible part of the society.
I would like to take the assistance of the technology expert who is here. Now, we are having a situation where a person is accused at one point of time, and later on he is, of course, acquitted. There is information before he was accused, during the period of trial, and then post that. Now, this technologically, is it possible or is it impossible to ensure that whatever information is disseminated, if it has got a relationship to something in the past, can that reference be always be part of the information dissemination? That is, what I'm saying is, if there is one news report on a person has been accused and arrested on such and such a day, there's one report. And after 3 months or 6 months, there is another report saying that the person has been granted bail, and after another 1 year, we may say it is acquitted. Sometimes this may take 20 years also, okay, or 15 years also. Now, when the news media or even the indexed Google search, when you make a search against that particular person's name, can it technically ensure that all these three sets of these things are actually presented when a person clicks on one of those things? When he clicks on his accusation article, there should be a note that since acquitted, something like that, reference is here. Is it technically feasible for technology to have that disclaimers being associated, which means that every article needs to be tagged to a very related article? Okay. Now, I think today's technology provides for that, because when you define a personal data under a data protection regulation, a personal data is a combination of name, address, etc., etc. It may be all available in different places, but your data governance system gathers that and say, here is the name, here is the email, here is the mobile number. All these three has to be combined into one personal data set. Now, when we can do that in terms of the personal data, if I have got one article here on accusation, another on trial, another on say acquittal, can it not be combined by the newspaper agency or the indexing agency? That the reader always has a complete picture of the case. Now, if I as a court ask you as a technology person, is it feasible? What is your view on that?
Sir, if you look into it, it's like, we are doing in the tables, okay, where we want to redact. For example, you take an example of a finance part of it, where, I don't want to pseudonymize the name, but all the details has to be there. So I would ideally create two tables, okay, saying that, in one table, I would have a name Abhay Varik. I'll have a connected name as 123. Okay. Now, if I have these two relationships and pseudonymized one part of my table, obviously with 1, 2, 3, I can, do whatever things I want. Whenever the system requires that you need to understand what is 1, 2, 3, okay, I can retrieve that data back with the help of pseudonymization, and with that single field, try to identify these two. So it's very well doable solution. It's not that it's not kind of the way, as you rightly said, if I can search and consolidate and have the data together, it's the same way I can, separate my data together, keep one data which is required in terms of pseudonymization, and move ahead on this part of it.
There was a recommendation of this type about 15 years back in respect of a website called dalitstan.org. Okay. But technology never at that time perhaps was not capable. I don't know. But today I'm sure you can check that this thing separately, and the government council also should bring this to the notice of the government, that the recommendation made at that time by an expert was that whenever a person looks at dalitstan.org website, there should be a pop-up which says that this is a disputed article. In fact, this kind of a thing is done in many cases where there is a dispute. And in fact, in the personal data protection also, if the accuracy of the information is in doubt, this kind of pop-up is recommended in law. I'm suggesting whether the government council can recommend to the government that in the case of this in judicial process cases, okay, we'll define it as in judicial process cases, that when you tag a judgment at the lower court, then when it goes on an appeal, trial, or from the police investigation, it goes through this thing, there has be some kind of a tagging of the core material case, so that at any point of access, the person who is accessing, who is an army kind of a thing, a person, he is not misled into believing that he was arrested is the only information as far as this is concerned. He was arrested on such and such a day, but he was acquitted on the next day, or something like that, should always be coming together. Whether that kind, like you call it as something as consent tagging, is it not? In a data protection area, we say consent has to be tagged to the data set. If you can do tagging of consent with this, then the information of case 1 and the information of case 2 can also be tagged, is it not? As a technical person, you say yes or no, and then we will ask the government council whether they can explore this as a part of a rule making, so that the media companies will also have the freedom to publish, because anything they publish is no longer misleading, because what they state is always coming with the counter view, so that a person who is looking at it is having a complete picture, and that complete picture is truth. It is history. A person was accused, he was acquitted later on. That is truth, and that should be the one which the right to information provide. So don't you think this will satisfy all these stakeholders?
Sir, as you rightly said, the data at the source itself has to be taken care of. And where the data at the source can be taken care of, okay, then with respect to the judgment where it comes into it, okay, we can really then, with the looking into the media industry or to the search engines, okay, then it makes a lawful basis for both, for the search engine itself as well as to the appellant or to the sufferer who wants the data to be delisted or delinked into it. Okay, so with technology, it can be very well possible, but it has to be addressed at the source itself. If you say that, I would address at the intermediate level, then it's a challenging for everyone in this case.
Now, before we go to the government council, let me hear with Ruchika Kumar once again, whether they will have any objection to saying that a person was accused, no doubt. But if every time I'm saying a person is accused, I'm saying, but he was released or something like that. And if the tagging of the information is done like that, would it be satisfactory for them? Ruchika. Yeah.
Your Lordship, I really appreciate the innovative solution recommended by Your Lordship. However, unfortunately, in the social scenario that we are looking with, the social stigma that is attached to a person who's once accused lasts a lifetime. So I do appreciate that you are trying to look for some kind of a solution where things can fall in place for everybody. But unfortunately, if the social situation was not what it is today, the social stigma which is attached to it, and my client was able to carry on forward with life with dignity once it is told to people that he has been acquitted, then things would have been, then this kind of a solution would have still made some kind of semblance in our minds. However, in the current social scenario, I'm sorry to say, Your Lordship, it still does not take care of the concern and afford my client the right to live with dignity.
I accept your viewpoint anyway. That's your viewpoint. Now, the other team of Neha and others, do they have anything to say on this kind of a solution which we are talking of, if they are available? Otherwise, we'll go back to the government council. I
have one question for Ruchika.
Yeah, Kodanram, you have
I have one question for. Actually, it should have been to Neha. They are appearing to be not there. So we will shift it to Ruchika, madam. She is well experienced. If we make it pseudonymous or anonymized, even in the matrimonial cases or other in-camera cases, if they are published, is there any harm? I think Neha is there. I think you are able to get my question, Rohita. See, in matrimonial cases, in-camera cases, make it as a general thing instead of it. If we make it pseudonymous or anonymous, can we still publish it?
Sir, I think the facts or the matter can be published, but publishing the names of the parties is something which I think the court should refrain from, because one, the social stigma comes along, and along with that, I think
Go ahead now, I think, no.
yeah. So, sir, one, the social stigma comes along, but along with that, I think if the parties are not okay, since it's something very private to them and it's about their personal life, be it matrimonial cases, be it their child's custody or anything with that, of that concern, being it something very personal in their life, publishing the names of the parties is something I think the court should refrain from. The matter, on the other hand, yeah, can be put across, but I think the names of the parties should not be put up or published.
Then you are giving away your version that all in-camera should be protected.
I will give an example. Okay, let us say there is a case where it's a divorce case. Okay, the divorce is carried. There are many habitual people, divorcees kind of a thing. There's people who marry, remarry, and then only go for divorce. I think we have seen that kind of cases in Karnataka itself. Some person who has married thrice, four, sometimes without divorce, etc. Now, let us say that we are adhering to this principle of no disclosure of names in any such matrimonial cases. Are we harming the next victim of that particular person who may go for a subsequent marriage or something of that nature? Are we not entitled to look at the innocent persons who may get harmed by trying to suppress this information. This, of course, will also apply for the criminal cases. I am taking the extreme case, even in matrimonial cases, it could perhaps be possible that merely taking a stand that matrimonial cases, we should not publish the name so that we don't know who fought, who this thing, whether there was domestic violence in a particular case. That's an important case. A divorce has happened and subsequently that person goes for remarriage. Whether the previous divorce was accompanied by domestic violence or not is also a matter of interest. The next lady who wants to marry may be willing to marry, but her decision may change if the earlier divorce had a component of domestic violence. Now, if the courts take a decision that we will never disclose the names, are we not hurting the public interest in a way? Is it not public interest in a way that the suppression of information may be detrimental to the interest of somebody else? So let us hear both you and Ruchika see whether you can yield on your grounds and try to recognize public interest also as a kind of a reason. Okay, yeah, and Vaishnavi and Neha first. Ruchika is very strong, so I will come to her last. Okay. Yeah.
Your Lordship, I would go from a perspective where it is up to the discretion of the parties, like the example you gave, that if there is a domestic violence background and the person wishes to remarry, I think it is up to the discretion of both the parties and the personal choices whether they want to discreet this particular information in their next. We're not specifically speaking about the protection of the next party, but we are also speaking about the right to privacy. So if we consider which is important, I would say that the person would have changed. So maybe he may be having a background of domestic violence in the first matter due to various other reasons. But we are not supposed to disclose that, and it's not always right that we disclose the information about some other parties. And I feel it's very subjective to the person, and this is a personal matter and should not be interfered by the courts. And a particular institute like marriage is a personal choice and not a public interest matter. That's what I believe.
Ruchika, we are back to you. So have you made any change of your viewpoint on whether public interest is paramount and we should look at these private interests yielding to that? Is there any possibility that a criminal of today may also be a repeat offender in a next this thing? And if there is also a technological solution that defamation aspect of it is taken care of to some extent, by only giving facts. Of course, if a person has been accused, whether rightly or wrongly, that cannot be suppressed. But if we say that he was accused but acquitted, kind of a thing, if there is a technical solution for that, then would it in some way support the view of a public interest over the right to forget kind of a situation?
Lordship, to begin with, the public interest is not in dispute at all. We are not saying that public interest is not paramount. That is, we're definitely not questioning that at all. Our limited question is the rights of my client, how we can safeguard his right to live with dignity. Firstly, with respect to anonymization or pseudonymization of the personal information, that is something that will be acceptable to the appellant, as long as his personal information is not out in the open and all over the place, and he's not getting prejudiced because of that, and it's not affecting his right to live with dignity. We do not have an issue with that, as long as the judgments, the details available in the case title as well as in the body of the judgment is pseudonymized or anonymized. Absolutely okay with that. when your lordship raises the question of what if the appellant commits a crime again or some, there is a due process of law which is available for this kind of situation. We are not saying that if he is to be obliterated in toto, but if there is if there is an offense committed, or if there is something which is he's accused of something, then the due process of law has to be followed. But whatever has happened in the past, if something if he's wrongly accused 20 years before, the same thing, and 20 years later he's being accused for something which is totally unrelated, how does that come into the picture? How does this affect the judicial process?
Okay. In fact, if you observe this, Kerala High Court did have an opportunity to discuss whether sending information to oblivion is what people want when you say right to forget or anonymize. To what level you would like the courts to go? Like now, suppose the registrar is told that whatever information you give to India Kanun or something, you will redact the name or pseudonymize the name. But suppose somebody applies for a certified copy of the judgment, taking the nature of the case from the search engine. Let us say he gets the nature of the case, and this person is interested in understanding how the courts have viewed that type of case. Then, though he doesn't know whose case it is, now he wants more details about that particular case, because Google has said that matrimonial cases 1, 2, 3, these were the things which were there. And he goes to the court registrar and asks for a certified copy. Now, in this certified copy, which is an official record of the court, do you think it should be acceptable if the correct records are given, or you would like that also to be pseudonymized or anonymized?
Your lordship, the records which are maintained by the court, they have to be how it is. However, if the records are being shared outside of the court, when copy is given, whether it be a certified copy or a publication, then the information, the personal information of the appellant ought to be redacted or pseudonymized or anonymized. Because if it is not done, then the whole purpose of coming before your lordship gets defeated. Because you cannot, try to find a solution to a problem and then create a new one with it.
Yeah,
as long as it is in the court files, it's absolutely okay. But if it is a copy which is being issued to anybody, then yes, the personal information of the appellant ought to be protected.
Lordship, as an officer of court, I want to add something, because in recent Mumbai High Court judgment, EBC versus Union of India, the decision makes clear that name should be hidden, name should be masked, and the copy should be published. So the names must be hidden when copies or certified copies are asked by someone. That is the Mumbai High Court judgment. So lordship's contention is that name, basically the person is interested in knowing the facts of the matter, the circumstances of the matter. It doesn't matter whether it was committed by ABC or it was only concerned of what exact matter has happened. So Mumbai High Court judgment has clearly mentioned that name should be pseudonymized, and lordship, it was criminal matter. So my limited contention is when there are different arguments or different judgments from different high court benches, this is the proper forum where this particular matter has to be decided. Because Delhi High Court in criminal matter asked for right to be forgotten to be adhered. Mumbai High Court, same verdict. And here Kerala High Court is coming with some contrasting or conflicting verdict.
Okay,
or settle this
I
matter.
would like the government counsel to actually respond. Before she responds, I want her to take a look at what the Puttaswamy judgment had stated. I think this was a statement made by Justice Chandrachud, para 69. It said clearly, such a right, that is the right to be forgotten, cannot be exercised where the information or data is necessary for exercising the right of freedom of expression and information for compliance with legal obligations, for the performance of a task carried out in public interest, on the grounds of public interest in the areas of public health, for archiving purposes in public interest, scientific or historical research purposes, or statistical purposes, or for the establishment, exercise, or defense of legal claims. So in all these cases, right to forget need not be recognized is what Puttaswamy judgment has said, and the Kerala judgment, the High Court also appears to hold a similar view. Now, Kerala judgment also says ultimately it is the government which has to give the law. So the ball is now in the hands of the courts of the government, that you are now coming up with a new law. If and the draft is there, and from what we see in the draft, there is no mention of the right to forget. But I would like to know whether the government would like to go for a more clear view, now that this controversy has come, whether we follow the GDPR principle of right to forget, or we follow the earlier version of FDPPI, where right to erasure, right to forget were both recognized, but the right to erasure was subject to some kind of a judicial oversight. Or the third category, which we now say that there is no mention of right to erasure, we will only talk about, right to forget, we will only talk about right to erasure. There are three alternatives before the government. Now, I would like the government council to actually tell the court what is the kind of view which you would like to recommend the government.
Your Lordship, coming back to the issue at hand, firstly, as counsel for the government, it is for the court to direct us. But also having said that, Your Lordship, there is a consent mechanism that has been established for a person under laws like GDPR and other privacy statutes, where a data subject gives consent for usage of his personal information. Now, these organizations have to, they restrict access to such data by any external forces, except in certain cases, as you mentioned, compelled disclosure, which is what today the law or the system provides for. Basis three principles that was also laid down in Puttaswamy judgment, as I mentioned earlier, Your Lordship: legitimate aim, proportionality, legality. So, but having said that, when the same information moves out of organizations and comes into public realm, simple example, Your Lordship, if you're filing a case before the courts in the litigation system, or I'm applying for a visa, now a lot of our public information goes into realms which are not organizationally controllable, Your Lordship. These are entering into other databases which have multiple access by multiple authorities as well, Your Lordship. Now, the way it is looked at is the outreach of data versus other fundamental rights of an individual. Where there is right to privacy, there is also right to information balanced with social and national interest. So right to erasure is not an overarching right to be forgotten, Your Lordship. It is merely a possibility to have data deleted in certain circumstances. And those circumstances, as of today, are provided by law under few enactments. CRPC says so, Hindu Marriage Act says so. The way the new data protection legislation will come about is more towards organizational compliances vis-a-vis national interest. Your Lordship, when it comes to public interest, national security, health, we recently came out of a pandemic, or at least we are still somewhere on the other side of the pandemic, Your Lordship. Now, these are extreme cases where a lot of sensitive information was important in the interest of public, Your Lordship. Now, in those cases, the court may make all the recommendations that can be put into the new data privacy legislation, but privacy as an absolute right cannot overrule the other fundamental rights, Your Lordship. Right to information is also a fundamental right which the state has to protect for all its citizens. So in a nutshell, Your Lordship, all fundamental rights have to flow together. No data or no one fundamental right can be held supreme or absolute vis-a-vis another, Your Lordship. And that will be determined by courts on a case-to-case basis eventually, Your Lordship.
Okay. we have heard all of you and made notes of your views. If anybody seems to have left out any point, this is the time you have to perhaps come out and make your final counter, if any. Otherwise, we would like to reserve our order for the time being, and then, yeah, Mr. Ilme. Yeah.
Lordship, I want to only make one submission that we will be very much glad to follow orders passed by the court. Our humble request is those orders should be in black and white, and we should be able to follow those particular orders so that we should not be blamed for contempt of the court. So we are always with the court and we want to do business ethically. That's my humble submission, Lordship.
Yeah. Okay, Mr. Kodanram, will
I think adjourn it for the day.
Yeah.
And reserve orders.
Yeah. We will close the court session now, so that we will leave some 20 minutes at least for open discussions outside the court. Okay, so that our objective of having this whole session as an educative this thing will continue. We have not given opportunity to the participants to raise any questions for this moot court session, so that along with the participants here itself, if you have any discussion after you can remove your coat if you want. As a privacy professional, you can always take that discussions. Yeah, Manju, any questions are coming from?
Obliged, Your Lordship.
Yeah.
No questions so far, sir.
Yeah, and we will ask them now. Mr. Subramaniam, Samyogita, Ram, Veluru is there, Prakash himself is there. They should have some questions or comments on the arguments made by various people. Yeah, nobody else is there. Prakash at least should have.
Lordship, I have one question for Lordships.
Outside the Lordship. Okay.
You know
that courts have asked people not to address them as Lordships. If you say
sir,
so. Okay, I didn't want to disturb you, because if you are used to that, then it is different. But otherwise, yeah.
Sir, is it not improper for government to specifically include right to eraser as well as right to be forgotten in the draft DPDP, what they have published? Because they have omitted one provision and kept one provision. In PDPB, it was both the provisions were available, and DPDPB, only one provision is available. So is it not causing confusion amongst the privacy people that what is exactly in mind of?
It does cause confusion because it was there in the one version and it is no longer there in the current version. Otherwise, perhaps India did not have right to forget earlier. Even today's Information Technology Act Section 43A doesn't have right to forget. From that stage to the new DPP bill, it would have been a direct transition. Okay, nobody would have asked why this is not there. But in between, we went into this right to be forgotten and then came out of it. So therefore, there is a confusion. I don't say it is not there. But the government can clarify that we have taken a view that earlier we made right to be forgotten as a matter which an adjudicator only has to decide, not the data fiduciary. So we had already made it a very restricted right. We did not want the data fiduciary to actually provide the right to forget on its own if somebody makes a request, which in GDPR case, it is more or less like that. If the data subject wants the right to be, right of forgotten, right to be forgotten to be exercised, then the data controller doesn't have any, kind of an excuse. He can perhaps say legitimate interest or something like that, but otherwise not much of an issue. Whereas in India, the earlier thing very, very clearly said that you go to the court, that is the adjudicator's court. Okay, whatever limited powers it is there, let them decide. They never said that the data fiduciary will decide. So from there, if you say that now they have removed that provision also, you may say government has decided that right to forget is it is not the time in India to have right to forget. because we are still worried about our terrorist to this thing. You look at, let's say, CCTV footage. Now, suppose I apply to the government that where all you find my picture in Bangalore city, you please delete it. I am exercising my right to be forgotten in all the CCTV footage. Then it is something which government may not like to do. Okay, they may say, no, we will keep your pictures in all sensitive locations. We may take it out in some other locations, kind of a thing. So government might have found that this right to be forgotten time has not come in India, and therefore they might have taken. I am only trying to find some kind of a argument for Trupti. Okay, so it can be justified either way. So, but the government can specify. Now, based on these questions, government can come up with some explanation at least outside the law. They don't have to put it as an explanation there. The minister or somebody may say, yes, we considered right to forget, and we thought that we will consider it at some future time. Then this argument will not be there. But people can still go to the court and say that it should be there, right to erasure and right to forget is same. These kind of arguments can continue in the courts, but the government can clarify.
Actually, Navi sir, I just wanted to add one point to it, which was not in the realm of arguments, and that is why I didn't present it there. The idea actually, I think, is also a distinction has to be more clear in which sections can we apply right to forget vis-a-vis in which sectors can we apply right to erasure. Now, if somebody tells me it is a litigation, sir, it impacts a lot of things. Today, my job application, there will be background verification where you have to declare litigations. It could be in passport applications, visa applications, bank loans. There are so many other angles that will get affected where public authorities require this information to make an informed decision about the person.
That is very easy to do in the sense that you can declare something as sensitive information and critical information and say right to forget or will not be there in critical information. It may be allowed in less sensitive information by classification of the.
No, Navi sir, sometimes I'll tell you the road challenge, real ground challenges, Navi sir, is sometimes I could just be a witness in a case. I may not even be party. Or, sometimes you could just be part, you may become some expert in some case. As counsels, all of us sometimes are called upon to give some sort of this. So the point I was trying to make, Navi sir, is also depending on the role you play. Now, there could be one bucket to it, which will say the minute it is litigation, you're falling under court system, and court system itself should be exempt from right to be forgotten, because otherwise it will disturb the entire judicial balance. Because a public open court system is a need, sir. It's a democratic need. It cannot be answered.
But today, I think the judges will determine at the end of the judgment whether it should be published or not published. Am I correct?
Absolutely, sir.
So likewise, in every judgment, they can also take this view as a mandatory this thing, that if any personal information, it should be handled in level 1, level 2, level 3 or something like that, which absolute anonymization may be given in certain cases. For example, witness protection itself may be a reason. Okay, in terrorist cases, a witness who gives evidence, he is at his personal life risk. Like that, it could be there. So
absolutely, sir.
Maybe in every case, the judge may take a decision that.
Also, sir, it is the person, right? Like today, for somebody, hypothetically speaking, I may be suffering from AIDS. I may have pregnancy. I may not want that to become public. I may want it to be sensitive. I know today we consider medical data sensitive. There may be certain issues like COVID, for example, though it is medical data, you were required to make it public.
Yes.
So now it may also depend on the prayer of the person that, please make it.
Ultimately, the court will have to take a case-to-case view. Okay, we are just looking at whether there can be at least some base ground created for that. Mr. Pratyush had some question, I think. Pratyush, you can unmute yourself and then speak.
Now, sir, I was about to ask in terms of the background verification that the various companies utilize.
Yeah.
Now, if the candidate utilizes right to be forgotten, so how effective is this in terms of the background verification, and what would be the pros and cons? that the organizations have to face.
Anybody else would like to answer that, Limie?
Yeah, that's what it was made clear that what could be the sensitive information, personal information, critical information. We have to be very clear about that, because some information may be critical for one particular sector, some information may not be critical for that particular sector. Like what Tripti just mentioned, that is witnesses. Witnesses are very critical in criminal matters, but witnesses are not so critical in normal civil disputes. If you give list of witnesses or some evidences, etc. So it is all on case sensitive or case to case basis. So there cannot be any blanket order that this should be forgotten, this should be erased, this should be etc. But that's why this problem is becoming murkier, because every sector has some importance for some information, and if that particular information falls within critical information of that particular sector, like background verification, whether the person has previous criminal record, if right of erasure is given to that particular person who had previous criminal record, and if you are asked to appoint that particular person as a security guard of your organization, will you ever take that particular risk? So this information or this right of erasure or what previously mentioned, that in matrimonial matters, if person is divorced, he hide that particular information and again remarries, and again the trauma happens. So every information can be critical for one particular sector. So we need to collectively say, make this sort of set of distinction, that what information is sensitive for which sector, what information can be critical for which sector, that will serve the purpose. It can't be black and white, these characteristics are PII, these characteristics are not PII. That is my take on this.
Okay. Anybody else has got any questions?
I just wanted to add to Dr. Limai's point. I completely agree with you, because sensitivity has to be looked at what is sensitive to the person as his privacy and what is sensitive at large to the society. As you mentioned, banking sector, they require no criminal background. In every contract you sign, they will ask for that this person should not have had any criminal case against him. Doctor, if he has a medical negligence case, even not even decided, just the fact that there is a medical negligence case against him in court. So just wanted to add to that, it is not sensitivity just from what is sensitive to me as a person. I may be very sensitive to even, I don't even want, my photograph somewhere maybe. But it may not be sensitive as for everybody else in public interest. So I think that I just wanted to make that the sensitivity should be looked at from both sides.
Sir, in a lighter vein, if you mention lawyer in application of loans, most of the times your loans are rejected.
Sir, even credit card and house for rent, none of them we get.
So this is not sensitive information, but we think this is sensitive information because our loans are rejected only because we are lawyers.
No, even the police also like that. Okay, but anyway, agreed. Yeah. Anybody else? So, Anju, you can take over for the final thing.
Okay. Thank you. This specific privacy right to be forgotten, has actually had a ring of mystery to it. Today in this session, you gave a 360-degree view of this right and interpretations from all aspects. So thank you very much for this educative and thought-provoking session. Sincere thanks to Navi sir and Kodandram sir for spearheading the discussion and sharing your inputs and insights. Thank you, Dr. Limai, Ruchika, Abhay, and Tripti for the wonderful efforts you have put in to bring out all the aspects through your arguments. A special thanks to our young lawyers, Vaishnavi and Neha, for taking up this challenge and joining this moot court panel. I also wish to acknowledge the efforts of some of our members in creating and managing all activities around this Data Privacy Day celebrations. You know, we had our Data Privacy Pledge and this program. So thank you, Satya, Dr. Anirban Sanyogita, Ramesh Kota, and Ramesh Venkatraman. And thank you everyone for joining. Have a good evening.